this is Roberta Rogers with Stewart title, and she's gonna be teaching director class. Andy Gus is our
Sales and marketing, along with Patrick and Michael.
Okay, how are you guys? Thanks for coming. Good. So we're all very quiet today. Really quiet. We get busy, doesn't it?
Good stuff, huh?
And does anybody want to get some food? Don't be shy. Because it's there for. Hi. Nice to meet you. So since we have kind of a smaller class, I like to. Do you want to?
No, I was just, I have enough, but I think it's just, clicking over the mouse to change the.
Oh, the slide.
The arrow to your.
The right
Yeah.
click on the mouse. That goes forward.
On the arrow too of the keyboard.
Okay, gotcha, perfect.
Are you giving me my clicker?
I can be your
Okay. Perfect. So anyway, since it's a little smaller class, they introduced me. I'm Roberta, and I have been with Stewart about a year and a half, and been in the business 29 years. And so I'm excited to you guys maybe just go around and introduce yourselves and let me know how long you've been doing this. They did introduce, I think, briefly our team here: Andy, Gus, Patrick, and Michael. And all sales, business development, they're an extension really of escrow. We have a great escrow team. The flyer that you have that was handed out, I'm not handed out. We have a great variety of escrow officers from which to choose, just like we have a sales team. And we all pride ourselves on really doing a great job for you and the clients. So the list here, we have offices in Carson and Gardnerville too. If you happen to have that, a need there, which is helpful because I've worked places that don't have that too. And that's, it's not the end of the world. It's not that far, but it's definitely more convenient. So can I start with you?
Okay, my name is Rich Coloibo, and I've been in this business 14 months, 13 months.
Oh, okay.
Yeah, I was in the Sparks office, and then because it's March, I started taking class more. So,
All right. So how you like it so far?
good. Yeah, it's good.
Yeah.
Everybody's kind.
That's a good place to start.
Yeah.
Right. Yeah, well, very nice to meet you.
Nice meeting you.
Thank you.
I'm Jude, Jude Callahan. I got my license in October, so 3 months ago. And I'm wondering whether I like it or not.
Me too. It's been 29 years. No, yeah, that's great. It's definitely kind of been a different couple of years in this industry. So, but you will learn a lot. There's a lot to learn. So that's always beneficial. So nice to meet you.
My name is Sarah Carrasco. Don't be intimidated by what I'm going to say. Okay. 1, I've been licensed for a year. 2, I spent 20 years as a title officer in Southern California.
Oh, good.
And 3, I'm a real estate attorney.
Okay.
But I do believe in what you just said. We continue to learn
Oh,
because
yeah.
things change.
If we don't, then yeah, we kind of fold up and all that stuff. And I can't say much for any other industry because I haven't really been. I was in banking for a little bit before I got into this industry, so there's obviously constant changes there too. But this industry definitely continues to evolve and change, and some might say it devolves on in a given moment too. But there's lots to continue to learn, which is really escrow and real estate. One of the best parts because you don't really necessarily stagnate. I learned something new. I don't know about every day, but frequently. So
Pretty much.
yeah. So thank you. And I'm only just a little bit intimidated.
My name is Angel Torres. I've been in real estate for a while. Getting licensed here in Nevada. I'm still waiting on that. I've been doing real estate in Hawaii, and then I also have experience in title and escrow and property management. And
In Hawaii or here or?
California.
Okay.
So I've been all over. And so I'm waiting for my license here, but in the meantime, I've been investing. Yeah, just waiting for my license here.
Yeah, so, do you have any ETA on that? Do they-
They said 8 weeks, and I think I'm on my 7th week, so we'll get to the finish line. Yes.
Well, thanks for being here.
Yeah.
Hi, Taylor Robinson. I've been licensed for, I want to say 6 months now.
Okay. And how's it going?
It's been good.
Have you had some transactions?
Yeah.
Yeah, good for you.
I do. My name's Carla. I'm coming up on a year with my license, and I recently actually partnered up with Veronica.
Okay.
It's been fun.
And Veronica.
I've been licensed since 2019, so about 2 years and a half now.
Okay.
And I am also the coach for Reno. One of the coaches here for Reno.
All right, very good. Well, thank you all again for being here. Oh, somebody snuck in. What's your name, sir? Gabriel?
I've been licensed for about a year now.
Okay, awesome. Well, thank you for having me. So, everybody that's here, I have a question for you. How many of you have done a transaction where there was, oh, there I am. That's where there was a trust involved? Okay. Was it a seller that was vested in the trust? What do you recall about that when with the title company? How about you, title officer?
It wasn't with the title company, it was a sale of the company. I know where you're kind of going.
Okay. So what I'm referring to is a transaction where it's just a real estate, residential real estate transaction where there was a trust, meaning like a buyer or seller was vested in a trust.
So we typically provide the title company with a certificate of trust,
Right,
which has certain pages of the trust.
right. And so you, if I'm not careful, I must be able to take my class and teach it. And then I'm gonna sit down and have some sandwiches. Tell me about your experience.
My property, we were doing a 1031 exchange from Florida to buy a property here.
Oh,
And
so
we
you
have
have a trust.
I do have a trust.
Okay.
Mhm.
That's usually my next question.
Yeah, and we, do all that paperwork. It actually wasn't much, I mean, it's a little harder because there's more paperwork,
Mhm.
but the signatures really is the only difference that I can remember in the transaction.
So you sold properties in Florida?
Yeah, in
Was
Florida.
the relinquishment and you acquired one here?
Mhm.
Okay.
Yeah.
Okay, and you were just vested in the trust, so
Yeah,
you relinquished from the trust and then you acquired the trust
yeah.
here. Got it.
Mhm.
Okay, so that brings me to my next question. How many in here by show of hands actually have a trust yourselves? Nobody, okay. Do you guys know what a trust is, what we're talking about? I mean, if not, that's good, because hopefully I'll be able to teach you something about it. So, the trust that I'm talking about, and then I'm going to just grab a paper and excuse me, is, and they vary from state to state, but, so I'm obviously in Nevada, so I'm going to be speaking to Nevada. I'm also not an attorney. I'm giving information generally to help you understand the process, why a title company asks for certain things, what we do with it, and why it's so important to get some of those things up front as opposed to towards the end. It's that really what I want to do is educate you guys to get you from the front to the back to the finish line of your transaction as seamlessly as possible. And sometimes having some background knowledge of why title's asking for this or that and how the differences change and potentially delay a closing are important. So, a trust, basically what a trust is it's a thing that's established, a legal document that's established, and it's part of a person's estate plan. So when you establish a trust, The idea is you, the person putting their assets into the trust, there's a couple different terms for that. And if you want to do perfect, thank you. Grantor, settlor, trustor. That is who is establishing the trust. So Andy, it's been a long time since we've done a trust. So let's say Andy and I are establishing a trust, and anybody can establish a trust. You know, people, individuals can, people that are, two people can, people that are married to each other can and do. Mike Gittner's going to do one this year because I told him I'd be on him all year. So we, the people that are conveying our assets, are the grantor, settlor, or trustor. That's the terminology for that. Typically, the way a trust is structured is whatever your assets are, whether it's real estate, cash, cards, etc. Everything should go into the trust. Because anybody in here know what the purpose of establishing a trust is? Why you want to?
To avoid probate.
Does anybody know what probate is?
How your family fights for your property.
I think it does, there's a trust too, but essentially, a trust helps hopefully mitigate that. It's a little more specific. So probate, we'll talk about it a little bit too. Probate is generally what's going to happen. It's a court action to administer a person's estate. So typically it can be pretty costly, and it can be costly emotionally too, more so. I mean, I can't go into this again, but because depending on how a trust is structured, it basically, when that entity is established, it's a living trust. And most living trusts are revocable. Most are, meaning that the original trustors, grantors or settlers, can change it, can revoke it, can make changes to it. Most trusts, and again, I'm not an attorney, I'm just kind of giving you general ideas. Upon the death of the original grantor, settlor, trustor, become irrevocable. And that's the whole point of a trust, right? People are establishing a trust so they can have some control over what happens to their assets after they pass on. So Andy and I are setting up a trust. We are the settlers, trustors, grantors. We are conveying our assets. We are going to transfer our properties, our cars, our bank accounts into the trust. And that's going to all be listed and delineated in that document, in the trust. Then what we do is we establish who the trustee is. The trustee is the entity that has the power to execute documents and make decisions about conveyances, anything changing, going in or out of the trust. Typically, it's going to be the same people. So most of the time, the grantor or trustor is going to be the same as the trustee. So we're going to be the ones that have the power during our lifetime to make those changes and convey, purchase, use the money, use the trust assets. Does that make sense? Okay. So what a title company needs, if you have a seller, and we're going to talk about a seller first because it becomes more critical on this, because we're insuring a transaction, we're going to want to review the document as the lady, I'm sorry, what was your name again? Sarah, as Sarah indicated, is that to review that the person saying they have the authority to sign for the trust is the one listed in the trust. So there's a couple different things we need, a couple options. One is a copy of the trust itself, preferably with the trust certificate. The whole trust contains all the information that not everybody wants to give out or have seen by us or anybody else for that matter. Most of the time, if you're having an attorney draw your trust, part of what that trust packet is going to include is a trust certificate. What the trust certificate does is it synopsizes the trust for pesky people like us, like title, banks, things like that. So we can get the brass tacks. What's the name of the trust? who are the trustees and what are the trustee powers. This document's also going to be executed by the trustees and notarized. That's basically going to be part of the kind of the requirement, and that's very standard. What a trust certificate will contain. Does that make sense? If the client says they don't have a trust certificate and they don't want to give us the whole trust, what we do see oftentimes in that, they come and they bring the trust binder to us and we just take out the parts we need. What we need in that event is we're going to need the face page of the trust, because the face page is going to tell us how the trust assets, how it's titled. The Andy Guest and Roberta Crown Rogers Trust dated December 7th, 2021. That's how the trust is titled. Andy Guest, trustee, and Roberta Crown Rogers is trustee. A trust by itself is not a legal entity in which to take title. It has to be us as trustees of our trust as we convey those assets. So that's not really your job to know and remember. That's our job to do that correctly, but just good information to have. So in the event where we're just looking at we're going to get the copy of the trust because there's no trust certificate, we need that face page that has how the trust reads and who the trustees are. We're going to need the section that talks about trustee powers. That could be anywhere from 1 to however many pages, depending on how involved the trust is. And then we're going to need the signature page and the notary page. Trustee powers portion, that's important, because again, that's the whole point. We are reviewing that to ascertain that people saying they are authorized to sign on behalf of the trust indeed are by virtue of that document. Does that make sense? Any questions on that part?
So if someone has their trust prepared and their attorney prepared their certificate of trust, what is the time frame? Do you rely on a certificate of trust that's older than a year? Is there a time frame that?
It's a great question. And that's going to vary from title company to title company. So where I used to work, they required, if there hadn't been a trust certificate executed within 2 years, they wanted us to have another one executed to confirm that the trust is still active. Everything is still the same, right? At this point, that's not a requirement of Stewart. As long as we have a trust certificate, the original trustors and trustees, then they just confirm that they have the power pursuant to the powers listed in the trust cert, and we move forward. So that's a great question, and that may vary from company to company. Different underwriting requirements. Welcome. Thanks. So any other questions around that? Yes, Michael. Yeah, please.
My life insurance policy is considered an asset. Should that be in the trust?
You know, I can't, to be honest, I don't know for sure. I can't remember on life insurance if that's part of the trust. So that's a great question. I remind me, write it down so I can get the answer. Because I really don't remember. There was a little bit of back and forth on that.
Ours was.
Is your life insurance showing the trust as the beneficiary? Or is it
Yes,
that?
but so, yeah, if we pass our life insurance, our beneficiary is the trust. So that's where the money goes. It goes into the trust. And it's,
Yeah, I definitely without giving any advice on that, just because I don't know the answer for sure. And that's something, obviously, we all want to be really careful.
No, I'm not.
So,
I have a question.
yeah.
Right, I'm on the flip side of it. Like,
Sure.
I've been looking to do trust for myself, especially because I have a daughter. But so kind of along with Sarah's question, is there where I have to be renewing that trust every so often, or?
No, you really
Is that
don't.
what-
No, but so yeah, that's I'm so glad you asked that, because that's kind of confusing. You don't have to renew your trust every so often. However, if you make changes to your asset situation, if you sell property or acquire property, you really want to kind of update your trust as things update. But there's no, at least here in Nevada, to my knowledge, unless something's changed recently, let me just put all that in there, hard fast rule that you have to update it continuously. what Sarah was talking about, and what big company that I used to work for, what they required, they just wanted something extra saying that, something recent. That in the last 2 years, so it's just additional covering them, that there's no changes that have been made that's more recent. That was their requirement. And title companies, we can just do a trust cert too. That basically mirrors what a trust certificate would look like, just kind of the brass tacks, somebody swearing that they are the trustees, they do have the power. Title people do prefer to actually look at the actual document that came from the client's actual trust. But there's some flexibility in that. So did that answer that?
Yeah.
Okay. So that's productive to, you're taking a listing, and how many people here do a property profile when they're taking a listing? How many people know what a property profile is? I think we're gonna let Patrick, will you give them a quick down and dirty of what a property profile is?
Yeah, of course. It's a tip of the iceberg about a property. So it's really helpful when you're going out with buyers, or if you are walking into a listing appointment. It usually comes in 10 sheets, and it lists how many bedrooms, bathrooms, the year it was built, if it has a pool, if it has a garage. It'll give you a quick history of who has held the property. Usually it goes back about 10 years, doesn't go much past that. So if it's a new build, recently new build, it's pretty easy. And then the property profile also will do some sales comparables, and then it will show, especially for your buyers, local areas of interest. So veterinary clinics, grocery stores, churches, everything like that. It's a really good tool. It's free to use, and we're able to get it to you by email, or we can have a nice hard copy that you can take to your clients as well.
It's got a vesting deed as well, and I'm always proponent of looking at that to make sure that if I call you up and say, well, what's the property, Sarah? And you look at the vesting deed and say, well, is Patty gonna be there?
Right.
And she's entitled with me, so that's an
Yeah.
important document as well.
Yeah, thank you. But both that's kind of the marketing component, what Patrick was talking about, the profile, and then what mine was just referring to as the brass tacks. But the other things that are going to be in a property profile is the current vesting deed and any current deeds of trust. So like in Mike's example, if you're talking to Patty and you have a vesting deed from Stewart Title that says Patty and Angel are entitled, then you can start that question. Okay, well, an Angel will be there at the appointment too. And you get to the appointment, maybe they say there's one loan on the property or it's owned free and clear, but you have a deed of trust in there. The deed of trust means there's a loan. Maybe it's not active, maybe it was paid off, maybe it was an equity line, it's a zero balance, I think was paid off, but there's still an active loan out there. So it really helps you start digging in and getting, look, first of all, you look really, really prepared and like you've done some serious homework, and then second of all, you are prepared, and we can start having those conversations sooner than you get into escrow and then get a preliminary report which shows that same information, and we start asking where's the other signature on that. So I'm a big proponent. If you're doing a listing, let us help you get a property profile. There's all that great like information with the comps and the area and whatnot. And then there's also the things that are really going to be what could potentially stop you in your tracks or be smooth sailing and confirm that who you're talking to is who's entitled. So that's a little bit of a little soapbox on the property profile. Don't get me started on the freedom. If we have a minute, we will do that. So any questions on that? And again, like Patrick said, you can get them pretty quick. We have a customer service department. They're really fast. These guys will bring them to you fancy if you want fancy. If you want information brass tacks, we're really there to get that to you and get it to you quickly, right? So if it's in a trust, if they tell you that it's in a trust, or if you do your property profile, you see the best maybe, you'll just want to give your client a heads up that the title company is going to want a copy of the trust certificate. And then people might get flustered or they may not, because if they've had a trust for a while, they know that this is kind of part of their course. So if they get flustered, have them call us and later we'll be happy to explain what it is we need, why we need it. So we can be the bad guys and try to smooth it over and explain what it is, and that nobody's trying to get into the business type thing. I don't see that there's so many more people that are vested in trust now and so much more action going on, you know, in that realm. I don't see that being as sensitive a topic, but for some people it still might be. So let us help support you on that. So next is we're going to talk about extenuating circumstances. This, if anybody, if you're going to take a listing and somebody says the D word, that somebody's died or there's been a death, please call us right away so we can start looking that information up. Okay, because there's all kinds of things that they're not in a trust that we want to look at and start working on right away. In the event you have a property listed in the trust and the original grantor, trustee, settlers, and trustees are deceased, and it's now their heirs or successor trustees that are selling the property, we will need the trust. We will also need the death certificate of the original trustees or trustee, if it's just one. And your client is going to need to establish a separate tax ID number for that. This is only when the original trustees have died. Your clients, if it's their trust and they're still alive, most of the time they're using their own social. If they are not and they're the successors selling, they have to establish a tax ID number. Also, when this kind of a transaction closes, most title companies, if it's your trust, if not your trust person, but if it's the original trustor's trustees trust and they don't have an account in their trust, they really should. Technically, as a title company escrow, we are to transfer the proceeds exactly as title is vested. If they're vested in a trust and they don't have an account in the trust, we're not making them go and open an account in the trust. And I'm speaking for Stewart Title. I can't speak to what other companies will require. We would have them sign an instruction that just says we're authorized to transfer the funds to them as individuals. But it has to be the same names. Okay. Thank you. I wasn't sure if that was allowed. So. Anyway, that is not the case in this scenario. In this scenario, the money has got to go to the trust. So they now not only need to have the tax ID number, they also need to have a bank account in the trust.
Can the tax ID number, so my grandparents died, I did everything. Can that ID number just be transferred to my social security or do they have to create an entire
Totally separate. Yeah, it's a totally separate EIN and because it becomes that's the thing about a trust and how it works is once the original people die, then it becomes a separate entity. And what happens is the successor trustees aren't even necessarily the beneficiaries of the trust. They may be one and the same, but they may not be. The successor trustees are tasked with carrying out the original trustor's wishes. So let's say in this, Andy and I are not married, but we're setting up a trust, okay, for whatever reason, who knows, but we want our respective spouses to be the beneficiary of the trust. Then maybe we want, maybe we're going to pick Mike Ittner to be the successor trustee because we feel like he's going to be a better choice to distribute after we're gone. So Andy and I can be the original trustees. We appoint Mike as successor trustees, and then Andy's and my spouses may be the beneficiaries. Does that make sense? Here's where it gets tricky and why we don't get involved in why we keep it pretty just in the box on this. We are not going to be involved in trying to figure out how to distribute the assets of the trust. That's the successor trustee's responsibility. So we transfer the money to an account established in the trust. And that's across the board. That's across the board requirement for title. So I would say it would be very fruitful for you guys to, again, if you know this is a situation, if you're calling on somebody that's my parents passed away, my grandparents, and I'm heads up and in case you didn't know. Now, if they're looking for an attorney or CPA, you know, they're a little more privy to that sort of information, then they will already know that. But I will tell you, I do a lot of, and most, at least 50% of them didn't know they needed a separate tax ID number and didn't know they needed a separate bank account in the trust. And the bank's going to require that tax ID number. So that's actually the order it goes in. Get your tax ID number and the only bank account. They're going to need that. Yes.
So you two guys, he becomes a successor trustee, but he's not the beneficiary. He
Right.
still has to get a tax ID number,
Yes.
even though he's not getting the money.
Because it's not for him. And that's, again, such a great point that you're making, because people do get that kind of confused, even the successor trustees that are like the kids or whatnot, they're in the errors. And that could be a problem if you're not working with, you know, a title company that really understands the component. Because if Mike starts putting his social in on all that, that's no bueno for Mike. I mean, that's not good. You know, you'll eventually get it unwound, but at that point, then things start getting reported by the title company under his social, which is not correct. He's just acting as the kind of the person. And even if he's the heir, I mean, he is also the beneficiary of the trust. It still has to have its own separate tax ID number. The beneficiaries will deal with whatever the tax implications are under their own socials at such time that they file taxes from the next tax year.
So bank account is, under the trust. Okay, not you.
Correct. It's the bank account's going to be named in the trust, and it's going to have its own separate tax ID number. And it's really, you don't have a CPA that would like, not, you know, if your clients or whatnot don't work with the CPA, it's a small trust, not a whole lot going on. It's easy. You just go on IRS.gov and get an EIN assigned and you answer a few questions. Some people in my office, really not escrow's job, but this was never going to get closed if I didn't help these people. We just sat down and did it on the website together to get them so we could get them closed to get them the money.
And it's an EIN, an employee identification number.
Yeah, or tax identification.
And okay, so we're not an EIN.
Well, yeah, no, it's a tax ID number. It's essentially a tax ID number. It's the 2 digits and then the 7 digits. Yeah. So great questions. So does that make sense? Right? Yes.
You know, something over the years, I've been doing this, it'll be 32 years. And I don't know how many times people will send us a copy of the death certificate, and it's a copy of the death certificate. And I end up down at the health department picking up a death certificate, the original, certified death.
Yeah. Yeah.
Just wanted to say that because you think you're covering all your balance and, you know.
Right. Right. And we don't have to keep the certified copy. We typically, as long as we've seen it, we can copy and give it back. You know, we know that you guys, that the clients only get a certain number of the certified and then they have to pay, or there's a lot to do. So, yeah. So this is really important. And I think in helping you guys as agents look prepared as you're going out and having these conversations. If you walk out and if you're competing with another agent with this scenario here, especially, and you start giving the prospective clients a heads up, and this is what's going to be needed, and I'm just going to let you know, that's definitely shows that you've done some homework and you're getting them prepared for what's coming down the pipe. So, any other questions on that? Okay, sir. As you guys are all fairly new, this class is designed for new and people that have been through, you know, maybe a few years, several years of transactions. Does anybody know what quiet title is besides zero?
Notice I'm looking down.
So if you're really lucky, you'll never have to know what this is, but people sometimes do things, homeowners, property owners, real estate owners, to how do I want to put it? Absolutely decimate their chain of title by recording deeds. They know not what they do. And sometimes, in order to clean it up, there's different ways to clean it up, depending on what the issue was with whatever was recorded. What quiet title is essentially is a court action to remove a cloud on title. It can't be removed in any way because either somebody clouded it and they're deceased, or there's another thing we'll talk about too, which can require a quiet title. But basically, this doesn't come up very often, depending on what the scenario is. And I'll give you an example. So I had a transaction recently that we inherited from a different company because there were two old deeds of trust, like from the 90s, that were not ever released or reconveyed. Reconveying into the trust means you can now remove it from the public record, and that evidence is that it's satisfied. So we reviewed it. One of them was a private beneficiary, and the other one was, I think, an institutional lender that's no longer around. Sometimes there's language in the deed of trust that may give you the ability to say, okay, well, we feel comfortable we remove this. It's been this many years, they've been foreclosed, whatever. Neither one of them had it. The private beneficiary deeds of trust can be even more difficult to get a title officer to say, well, yeah, we can just wipe it out. It's been 25 years, 30 years, whatever. So in this scenario, what was going to be needed was them to initiate a quiet title action to extinguish those deeds of trust. So what that means is they would go to an attorney and pay money and take time to initiate a court action to do the proper noticing to make sure that they can get via a court order those deeds of trust removed. Does that make sense? The happy note to this story was we didn't require that because once our title manager took some time and talked to the seller and got some additional documentation, and I won't bore you with everything that we obtained. We also were able to talk to the attorney for the estate of the deceased person and get a document signed. There was also some other documentation that looked like their intent was to release our property. There were several properties that were encumbered as part of the one deed of trust, and they all got released except ours. So there was a little inferring there too, but our title department made a decision to assume some risk, not require the quiet title. That doesn't happen in every scenario, and it's a total case-by-case basis. But to illustrate basically kind of what a quiet title would use for that was one of the directions we were recommending they go. So, and it's not a guarantee, not every title insurer will even insure that. So
What happens if you do and the beneficiary comes back? Can they pull my title from ownership of the home?
well, we've insured it.
So
So
at that point, you deal with it?
Yeah.
we put a claim in on your policy. Yeah. So that's a great question. Yeah, and that's what title insurance is for. And I'd love, if we have time, I am going to do a little sales job about the title insurance, the expanded home, the seller provides the owner's policy of title insurance in our area customarily, and then the buyer, if they want it, has the option to purchase that little additional, it's the Alta Extended. Is everybody aware of that? It's a more comprehensive. I'm not here to teach a title insurance class, but that is a very useful policy. And there was a time where agents were kind of telling their clients not to take out, you don't need it. It's literally 10% more one time at closing, and it doesn't cover everything. Nothing does, right? No insurance does, but it's a lot more comprehensive coverage. And well, I'm already talking about it, so let me just give you an example on it. So I just recently had a transaction that, a client of mine closed. He basically bought the property to fix it up and flip it. 3 days after he closed escrow, so we close, he buys the property, he records. 3 months later, we open escrow because he's ready to sell it. He's got a buyer, it's fixed up. We get on our preliminary order title commitment. There's a mechanics lien on the property for $6,000 for work that the prior owner from whom he bought the property was named. Well, mechanics liens, even though it was her bill and it was recorded after he was no longer the owner, mechanics liens stay with the property too. So he had purchased this extended coverage, and had he not, so it cost him, I'm gonna say $130, probably $130 for that price range. $130 is what it cost him. And he put a claim in on the title policy, otherwise he would have had to pay $6,000 and go back and try to, get it back from the prior seller. So there's an example of why that extended, and not every property qualifies for it. It's gotta be it can't be like a meets and bounds legal description. It's gotta be in a subdivision or a parcel, single family residence, owner occupied. And there are a few little exceptions on a case by case basis, but that's kind of the hard fast rules on that. So just kind of keep that in mind. And I would caution against telling clients they don't need something, because you know how that goes. Maybe you don't think they do or you don't agree with it, but definitely be careful with that, because you have to do the come right back to you. Okay, so
And you said that's 10% above. what
so like on the base policy for that one, it was $1,300. So the seller pays the $1,300. That's
10% so
seller set 10% of what the base cost is, so that's $130 in that case. And title insurance changes just it goes as the liability for the transaction goes up, so goes the title insurance, premium. It doesn't go up a lot, but by $3 per thousand. So, okay. Good. All right. Oh, let's talk about these. Does anybody know what this is? We just want that for insurance. Sarah? A massacre? Yeah, I mean, horror stories were here.
So deed effective upon death, I used them all the time prior to the last session. And it had to be someone that only owned one piece of property and had like a car, financial accounts, that's it. So instead of them paying $2,000 to enter into a trust to get rid of the property, as opposed to avoid probate, we're utilizing the deed effective upon death. So I would deed my house during my lifetime to my daughter. And when I passed away, title automatically, not automatically, you have to record an affidavit of death to establish that I'm dead, but it triggers a transfer of title at that point into the daughter. County recorder acknowledges it. Title companies have issues for 180 days because there's a lien period for when someone passes away. You have Medicare, Medicaid liens that they're entitled. 3 years, yeah. And now it's 3 years, okay, but more importantly, I don't know who, and I'm so frustrated. It was decided in our last session that heirs were losing their rights. Okay, so you have someone who's alive who chose to give the property to my one child. The legislature was convinced the other 2 children in a family are entitled to notice. Okay, this is being done before I pass away. But after I die, they're taking the position, I still have to file a probate case, give notice to those heirs, deal with the lien period, giving notice there. So they basically made that document ineffective.
Well, that's good information. I wasn't aware what happened in the last legislative session, but what I can tell you is we're not fan favorites of the deeds upon death, and exactly as Sarah said, it, the function, the purpose of it is great. If you want to be able to have a property that you own go to somebody specific, you record this document, that deed upon death, and all it basically while you're alive, it just kind of clouds the title, just as notice. That it exists, and if you don't die and you sell the property, it doesn't hurt anything, it just goes away with the conveyance deed to a buyer. If you die, and as Sarah indicated, then whoever that beneficiary is under that deed upon death, they have to record a document called like death of grantor, and attach the death certificate to it, and then the property transfers to the beneficiary. That's great, unless you want to sell the property or do anything with it for 3 years now. Because the NRS allows 3 years for Medicare and Medicaid to come back and lien a property. The other thing that's problematic with a deed upon death is it doesn't, and what I'm pretty sure is the legislature's issue about additional heirs, it doesn't give proper notice. So while a probate is not as seamless as a trust, because you do have to initiate a court action to get your person appointed, you petition the court to get whoever is going to handle the estate, and then there's time that goes by. In a regular probate, the property there has to be proper notice to creditors. That's the problem with the deed upon death. It doesn't give proper notice to creditors, potential creditors. And it sounds to me like the legislature, what they're talking about, is they're talking about other potential heirs being noticed and having that creditor notice. That's very, I mean, we're going to have to follow up and do some more research on that. But from a title company standpoint, it's a problem, and there's a waiting period. We don't want to insure unless that 3 years has passed. And then again, if the heir is fine with that, it's great. Can anybody else think of what other problems might come up for a person inheriting a property?
Cover the taxes.
Taxes, if there's a loan on it, HOA. So, and then now you have to do it for 3 years or potentially get foreclosed and lose the property. So I highly, highly recommend anybody that's thinking about a deed upon death, talk to a Nevada real estate attorney and see what estate planning options would be best for any given individual.
But that 3 year period, that doesn't apply to just a normal trust.
No, the trust can just, as long as it's proper in proper form and recorded, the deed. Now, here's a critical piece about a trust that everybody needs to know. Because it does change, it is different in different states. In Nevada, if your property is listed in your trust, you don't actually physically convey it via a deed into the trust, and you die, that property is going to go to probate. It will not be distributed through trust. So it's really important to have the follow through. And what happens a lot of times, we don't have a lot of people in here with trusts, but if you are vested in a trust and you go to refinance your house, the lender wants you to come out of the trust. If you don't, some title companies won't even put you back in the trust. To me, that's way more liability. That it doesn't even make sense. You want to get put back in the trust. But if the party does not get deeded back into their trust. And again, I've been doing this for a little while, so this has happened. They think they are in a trust, they are 100% sure, no, my parents had a trust, yeah, but they renounced a year ago or 2 years ago, and they never deeded back into trust.
Mhm.
I had to go through probate. So for your own selves personally, as you're looking at doing a trust or talking to clients, or that's critically important. Anything, and again, the trust itself will list the assets. But if you don't convey actually the assets, like a bank account, if you have a bank account and whatever, whether it's 500, 5,000, 50,000, and it's in your name as an individual, and you didn't put it into the trust, that's going to go through probate. So cars, same thing. Now, obviously, if you have a car loan, you may not have a lot of control until it's paid off, as to depending on who your lender is. But once it's free and clear, you want to have that in your trust.
No, you answered my question.
Okay.
Yeah, yeah.
Oh, yeah, you bet. So, those are really important things to be aware of. The deeds upon death, this just kind of harkens back, there's the D word again. So if you are talking to a client and they mention the D word, call us so we can see what is going on. If it's husband and wife, and the wife said her husband has passed away, or vice versa, anybody, give us a call. Let's get a deed. Let's look at how the property is vested. In this example, it's a husband and wife, and let's say the wife passes away. If they didn't have any vesting with it contained right of survivorship language, then there's a probate that's going to be required. So just things to be aware of. And the thing that's important to remember about that too is if you go out and list the property and get it into contract, if you haven't petitioned the court, that survivor doesn't even have the authority to sell or sign on behalf of the other person until the court's been petitioned to appoint them as the administrator of the estate. Because what happens in that scenario is it's not a husband and wife anymore, it's two separate entities. It's the estate of the wife and then the husband that's alive still and signing for themselves. So those are really important things that we want to catch up front so that your process is more and it's going to take longer, but it's definitely better than getting down the road and then finding out, oh, you get into contract and you get a court date and then that's going to get tossed because they didn't even have the authority to do it.
How does it
So
work when it's a good old will?
what's that?
How does it work when it's just a will?
A will's probate. It's just that having a will means you've died testate. That means you have a document that's a basis of what you want to have happen to your belongings and your assets. And then the job of the court is to try to carry it out, subject to all the people that come, potentially into the mix. If you don't have a will, you die intestate, and then it becomes a whole other situation. That's definitely not any easier. I mean, much but it's yeah. A trust is, depending on how involved the estate is, that's usually around, and what attorney, $1,500 to $2,000. How much does an attorney charge per hour? Yeah.
350. What I'm seeing, yeah.
So you definitely have a little more control with the trust, and you're not paying what happens with the will or probate your person. That money's coming out of the estate every time the attorney has to do something. So just things.
I had a thought too.
Yeah.
My father died and we didn't have a trust, we had a will, like you were talking about. And of course, I had to go through probate. But the big problem we had was paying the mortgage on his house.
Yep.
Because we weren't privy to that, again. And we ended up getting it done, of course, by a good attorney, but when I tell you $3.50 an hour, there isn't much you can get done in an hour, so.
So that's a great point, Mike. But lenders, basically, what we've found this out when my mom was several years ago, and she had a trust, and my sister and I were successors and beneficiaries essentially. So it was pretty simple. But what we found is what lenders do is they run social security number checks. I don't know, it probably varies from lender to lender, at least monthly. And that information, when it hits a death, then that loan goes to their death department essentially. And they won't talk to anybody until you can prove, whoever's trying to reach out to them, that you can substantiate that you have the authority or the right to have that conversation. So depending on what the estate planning situation was for the deceased, is going to determine what you would provide, obviously. And I'm not, but what we've had to provide in the past is obviously the title company, we have order payoff. And so that can take a longer time. We have to provide a death certificate. We have to provide, in the event like for the probate, that documentation showing that whoever was appointed administrator is appointed administrator by the court. If it's a trust, we have to provide the trust certificate showing that the person signing, and then they sign, giving us the authority. So a lot of nuances there to think about, regardless of what the estate, like I said, what the estate plan is.
Like Mike said, I mean, let's say that, he had problems actually being able to pay on the mortgage. So depending on how long it takes you to get all of those papers together to show that I have proof of ability to make that payment, can the lender take the house?
I don't know that they could do that. I've never heard of that happening. Let me put it that way. And I haven't heard that often that they won't accept payments. So that seems like that's maybe a little bit more of not as common of a situation. Where the problem that we've seen come in is just trying to get information or payoff demands out of them. So I'm not saying, I'm sure that did happen. And in this day and age, nothing is surprising with some of the lenders, but we haven't seen that as much as just the problem trying to get information or payoff out of the lender when the person's deceased. So, so deeds upon death, we just want to talk about it. If somebody tells you they have one and somebody's died, let's just give us a call. We'll look at it. We'll see what's going on, and then we can move from there. If it's been almost 3 years or things like that, there is flexibility. So I don't ever want to say that there's hard and fast. You just absolutely can't do it. There is more than one way to skin a cat, and we do try to explore those options. Like I mentioned on the situation on the quiet title, where we ended up not requiring the clients to do that. Yes, Sarah.
So do you know whether your company is going to accept waivers or release letters from Medicaid and Medicare?
They will do that,
Okay.
But it's a
That's
case
only
by
one-
case basis.
Yeah, and that's one part of what the issue is.
Exactly. Yes, but I have closed transactions where we were able to close before the 3 years with that. I don't take that to the bank, but that is a possibility. Again, we're trying, we obviously we're trying to strike a balance between both worlds, right? Do everything correct, protect and maintain the integrity of the title insurance and not have claims coming in, and also get deals closed for your clients and figure out ways to do them. That's it's sometimes a slippery slope, but we do walk it and try to where it makes sense. So, any more questions before we move on? Okay, so if you have a seller that is vested in an LLC, this is another one if you're going out to take a listing, that you'll just want to give them the heads up. Title company is going to need their operating agreement and their articles of organization. Articles of organization are available to us if the LLC is established in Nevada. We can go on the Nevada Secretary of State website and download that. This is not the operating agreement. If it's in another state, we may not be able to get access direct. Sometimes they want to, be paid, etc. So a lot of people are incorporating and LLCing in Delaware, and Delaware is a hard one to get in, and there's a reason that businesses are doing that. So the sooner your clients know we need these things, the better. I have one right now where I've got an LLC managing the LLC. So then we need that LLC documentation too. We got to drill it down to see who can sign. So at some point, a human signs, even on a corporation. So we have to be able to, again, we're insuring hundreds of thousands of dollars worth of real estate. We need to be able to ascertain if people saying they can sign and sign. And then other people have a trust that's the manager of an LLC. They're in most cases, we're going to want a copy of that trust too. So just kind of keep that in mind. What the purpose is again, not to harass people or make them crazy, but just because we need to substantiate who's signing and who has authority. So any questions on that LLC, limited liability company? So let's just really quick talk on the other side, because I keep talking about listings and sellers. Do these things with the documentation for LLCs and trusts are a lot more prevalent when there's a seller. When there's a buyer, a couple of things. If you have a buyer that's in a trust, did you do a loan or was your acquisition cash?
We did a loan, but it was, the seller is, the lender.
Okay. So a couple things. So the, with the trust, if it's cash, we don't have to have a copy of the trust review because we don't insure vesting, but we do request a copy of it because we'd like to do it correctly and name the names correctly, show the trust correctly, and just have that documentation in our file. But we don't get as involved, all up in everybody's grill about it like we do on the seller side. Same with an LLC. If an LLC is purchasing, we'd like to see, like, if the part of the people that sign the contract, people in the LLC, but we don't have to drill down to the same degree if it's a cash transaction. Now, if there's a loan or a lender involved in either of those situations, we are insuring the lender. So then it's going to be the same requirements that would be of a seller in that situation for a buyer. That makes sense? Most lenders don't lend to LLC. Anyway, but people have to take title as individuals and then transfer to their LLCs. Thank you. So that brings me to transfer tax. Yes, but yes, I was in.
I was in helping buyer and then set up listing with the LLC. And then there's some documents have been one person name sign, and then some is two persons sign. And then I was not sure because I was my first time here. So like, right, that's all. Title company's gonna check all that. They have a follow up. That you guys check for our agent, and then is that right? Right?
Yeah, and I would say that it would be prudent to get us a copy of those documents, ahead of time. If you're taking a listing in an LLC. Did you say it was your buyer or someone?
Seller, this thing was LLC, and my buyer was just maybe. Then I noticed that offer acceptance had two signatures on it.
Okay.
So that was LLC, and then I already know that, but as a document, it's only one person signed, not two persons. I was the one that questioned, but the listing agent was not very cooperative, and I was kind of embarrassing asking Megan last week stupid question.
No, that's actually a really good question.
Ask everyone.
So, he was very, not.
But you can ask the title company.
Oh, okay.
It's possible that they reviewed the documents and ascertained that only one signature was required, so they just had one signature. It's also possible that the two people were available,
Okay.
the two members were available to sign the O&A or the contract, but then they wanted somebody else to sign the escrow documents. So basically, we review the documents to see if we can make that happen and how we can make it happen to make it convenient. Or unless the LLC, which is the operating agreement, says something, otherwise these people have to sign.
Okay, so, even by your side, I can ask you.
100%.
Okay.
Absolutely.
Yeah.
Whatever. And you know what, if you ask a question that we can't answer, we just, we're not at liberty to disclose that. But I think that's like, basically, if you came to me and asked that question, I'd be like, oh crap, we missed a signature, or, oh no, we were able to ascertain only one was required.
Okay.
Yeah, that's a great question.
So in her case, the fact that it goes all the way through and title has approved it, she's released from liability.
Yeah, I mean, really, if there's
Okay,
something, if
she
your
will
buyer, if there was any issue around that, your buyer, again, that would seem to be, I'm not a title insurance underwriter, but that would seem to be if there was some failure or loss as a consequence of that, that there would be a claim.
Okay.
Yeah, good question. Okay, so transfer tax. Or is also referred to as deed stamps. But the real property transfer tax is basically the state's little portion that they take on every resale. It's different in different counties. Washoe County is $4.10 per thousand. Our outlying counties are $3.90 per thousand. Vegas or Clark County is, I don't know what they are now. They're at least $5.10 per thousand, maybe more. So that's all calculated. Typically, as you all know, in a regular transaction, the transfer tax is split between buyer and seller. Fun fact. I know Mike remembers this because he's been doing it as long as I have, and then some. The transfer tax in Washoe County was $1.10. 90, it was Kenny Gwynn was governor, and they wanted to raise money for education and some things like that. And it jumped from $1.10 per thousand to $4.10 per thousand. Now it hasn't changed again since.
So what did they do with that money since?
You know what? I don't have all the answers, Jude, just some of them. I don't have that one. Yeah. Yeah, I think there were some other things that it goes to funding, but yes, that's a great question.
Guys, on a high level.
Yeah, that could be it. Not me. So anyway, there are situations that you there's exemptions for transfer tax. I think there's 11 different exemptions. The most common one, you guys don't need to memorize this stuff. I'm just kind of giving this information. The most common one we see is an exemption 5, which is when there's a transfer of title between like spouses. I'm dating my spouse on or dating off, or parent to child. That's spousal and parent to child. Child to parent is known as an exemption under the first degree of consanguinity. Interestingly, if a parent is selling to a child and there is consideration of the sales price, there's still no transfer tax on that. They don't charge it as long as it's child to parent or parent to child. So that's how that was designed. If you have a trust, you can deed in and out of a trust as long as there's no consideration for that deed without having to pay transfer tax.
You have to purchase, don't you have to purchase the extended insurance for that?
Okay, yeah, which is a title insurance thing. So that's another thing that the extended policy of title insurance does covers deeding in and out of the trust, whereas the basic doesn't. What that means is if I buy a property and I just get the basic policy of title insurance, and then I transfer my property into a trust, that doesn't hurt me in that moment. Where that might hurt me is if I have then a claim that I want to put in on my title policy. And then I've engaged that transfer and I don't have the extended policy, the title underwriter may reject my claim because I transferred title. Whereas with the extended, it's covered because, you know, again, that whole refinancing, you go in, you go out, you change, do things going in and out of your trust. So that's covered under this extended policy. So good, thank you for bringing that up. So if you are an individual and you're buying, or and really the intent, let's say you wanted to buy a property in your corporation or LLC, and the lender wouldn't let you, so you're gonna buy it as an individual and transfer it in. And I'm not saying that you should do that, but people do it anyway. If the people that are in title currently are the same people that the LLC or corporation are comprised of, and there's no consideration, meaning zero, it's merely a change of ownership from me and Andy to Andy and my LLC, then there's no transfer tax. It's exempt. However, if you're transferring it back out, let's say, okay, now we want to get a new loan and the new lender isn't going to let us borrow in our LLC, there is transfer tax on the deed out of a corporation or LLC. Even if it's the exact same situation, that's just how I don't have the explanation, just like I don't on the $4.10, why you can't go out, but you can, and they haven't changed that without the transfer tax. And the transfer tax is going to be based on the most recent sale or the assessed value, whichever is higher, of course. So one way to circumvent that is if you have a trust, because the number 7 exemption, which is to or from a trust, as long as it's without consideration, you could go from an LLC to a trust, and then a trust to you because it's to or from. So it requires a couple of extra documents, a couple extra reporting fees. It's usually going to be quite a bit less expensive than transfer tax would be. So I don't recommend you guys walking through that like necessarily with clients. It's just good to know. And then if that scenario comes up or potentially comes up, let them talk to us and we can walk through and see exactly what the documentation is and see if it will qualify.
Is there a transfer tax on 1031?
There's transfer. I mean, anything with consideration has transfer tax except parent to child or child to parent.
Spouse.
And spouse to spouse.
What if it's a step payment?
That counts if they're still to get, if it's not like if it's as long as if like me and my husband, who's not the father of my kids, are transferring to my kids, yes. But if I'm no longer alive, that kind of brings that responsibility if he was trying to just do it. Yeah,
Yeah. We just pass it on to you.
that's you know what? That is fine. Yeah. So powers of attorney, you may have a situation where a client says, hey, I'm going to be signing any deeds, power of attorney, blah, blah, blah. Oh, sorry, Andy. So we prefer, if that comes up, please give us a call. We prefer to use our own power of attorney. Our attorneys compare them, they have the language that is preferable. That being said, if there's already one in play, we will, it's just not feasible or convenient to get another one signed or because they have to be notarized. So we prefer to prepare our own, but we will look at an existing one and we just send that to our title department. They review it and say what the parties need or not. The thing that we just want to make sure your client knows is we have to have the original at some point because we're going to have the original to record and say there wasn't original. So of course it has to be notarized. We need the original for recording. One thing that comes up for people with trusts is that they may, a couple things, and I actually didn't bring this up. If you have vesting with 2 people that are the trustees of a trust and only one signing all your documents and they just tell you, oh yeah, I don't need, our trust doesn't require both parties. parties to sign. That's all well and fine, but any title underwriter is gonna wanna know, okay, that's great, but why? Why isn't the other person signing? And we're most likely, obviously, we're gonna wanna review that part of the trust that specifies that. And we're most likely going to want to get something in writing from the party that's not something just any other party has the authority to sign. So just a heads up on that. The other thing is, sometimes people think that they can use power of attorney to sign for the other trustee of the trust. If they're not available and whatnot. Maybe. I am seeing them a little bit more in trust, but a lot of trusts do not provide for power of attorney. What happens, I think, is some people get confused when they get the big trust binder, because part of what is included in that, when you do the whole trust packet, is durable power of attorneys and the healthcare power of attorney. I think sometimes people get confused that those allow them to execute for real estate transactions on behalf of the other trustee, which those don't. The trust itself has to provide. So again, in that event, we're going to want a copy of that, the trust, to review to see if that's allowed. That makes sense. Any questions on powers of attorney or requirements on that? If you have a client going out of town, going out of the country, let's start talking about a power of attorney. We are able to start using remote online notaries. Has anybody done a transaction where the remote online notary was used? Okay. 2 years ago, didn't happen. COVID's definitely catapulted us into a different area, and people are out of town. I have a transaction that just opened, and he's on an island somewhere. There's I don't know, no mail, no UPS, no FedEx. So we can use the remote online notary. We just have to make sure if there's a lender or the buyer involved, that they're okay with the seller signing that way. If it's cash, then it's fine. We just use one of our vetted. So again, one of my favorite sayings to say it is, there's more than one way to skin a cat. So we try to find a way, but the sooner we know the information, people going out of town, ASAP, what do we need to do? Is there something that can sign a power? Somebody's overseas. The other thing I like to just squeak in is really important when you're representing buyers, and it's an individual or even more than one individual. Find out their marital status. Nevada is a community property state. It matters. And the sooner you find out, the better, because if there is a spouse that's out of town, out of the country, we can start working on figuring out what we need to do, because incarcerated, yeah, we get it all. And when they're incarcerated, depending on what security level the prison is, you just can't send a mobile notary to the prison. That's a process. So,
That's why it's all.
yeah. So, but it is important. Sometimes people make assumptions when we open escrows. We try to ask, when I see the paperwork come in and there's just one person or two or three, two with different last names, we ask what marital status. So that's a very reasonable question to ask your buyer. And that's the explanation that is a community property state, and we'll have to deal with spousal interest. We just closed an escrow. It was a cash transaction. So if you have a lender involved, that lender is going to require the spouse to either join in the execution or deed off. And that requires a notary. So the sooner we have that information, the better. And not all lenders are going to let you use the remote online notary. So if you have somebody in another country, again, they can't just go into the UPS store and get notarized. They have to go to an American embassy, and American embassies aren't on every corner. So there's a lot involved. And sooner we start that process to get that taken care of, the better. Doing it at the end doesn't help anybody in those situations. However, if it's a cash transaction, we don't have to have a spouse sign if it's not convenient or whatever. But the person purchasing the property, the lessee, will have to sign an instruction acknowledging that their interest in the property is subject to any commuting property interest of their spouse. And then that will show as an exception on their policy, and then they have to deal with it if the spouse comes in and makes a claim. So it's an option, and we did just have a gentleman go that route. We didn't ask why, we just made sure he was very clear what that meant, and then he signed the instruction and we closed. But this is all really relevant information again, and the sooner you have it and the sooner you get it to us. And we don't expect you to have some of the more title specific conversations. We are more than happy to walk your clients through some of this, really with the trust and why the spousal leaves are required and things like that. But it's good for you to know, the working knowledge of it. And read your prelims. That's another class for a different day. But read your prelims. And if you don't know how, find your favorite escrow person. We've got lots of great, amazing people at our company that can do like a little class with you, go through it so that you can at least identify red flags that might come up. It takes a village to get to a successful close of escrow. And that means all of us working together. And, we try not to miss things, but somebody may have been working in our unit one day, helping out, sent out a prelim, didn't see a tax lien on there, or didn't see that there were two deeds, something. So look at your prelims or your commitments that are coming in from the title company. It's really important. And just peruse them. If there's anything on there that looks weird, call the escrow officer or team or email or get, because you may notice something that we missed, and we try really hard. Our profession works really hard to be accurate and make things as easy as possible, but we might miss something. So it's just better if we all take that accountability.
I think something that sets us apart as well, not dinner.
No, please.
But we do have what we call a stoplight, and it used to be a prelim, it's now a commitment. But on that, it's either red, green, green, yellow, or red, just like a stop sign. If it comes in green, typically there's nothing to worry about. If it comes in yellow, there's probably something we're going to have to work on, maybe a trust or child support or something like that. If it's red, stop. We got things to clear
If you're
up,
getting
so.
a prelim with a red light on it, and that not all companies do that. We haven't called you, that's definitely, we want to have that conversation with you to give you what the heads up is and what we're doing. I have one right now that's, I don't know what's going on it. So I just sent the prelim and said, call me so we can talk about how to clean this up. So.
And do you guys, so you send me a prelim to say do I have the option of pulling my client onto a phone call with you? So you can explain it
Absolutely,
all?
100%, absolutely. Yeah, and again, we don't expect you to explain our documents to your clients. We want to involve you in the conversation and we want to take your direction. It's appropriate for us to go to you, and then you say, okay, we call my client directly, but I wouldn't want to call your client first and then have them call you, and you're like, what? I didn't even know they called. So, yeah, absolutely. Let us help you do that part of it. Luckily, these things don't come up that often, but they do come up. They're painful sometimes when they do. Do you have anything else that I may have missed? Probably.
Not that I can think of off the top of my head, besides if you guys do take the listing, definitely reopen it.
Yeah, we will do that.
Ask your title company, if they do a pre-open.
AKA Stewart title. Oh, okay.
Just because if there are problems on there, then we can get ahead of the ball. Because there's been some times where you get a contract and you send the contract to the title company, and maybe it takes 3 weeks for the prelim to come, and then you're set to close in a week, and there's tax liens, sewer liens, HOA liens on that prelim, you're done more. You're not going to close in a week. So definitely ask your title company if they pre for your listings.
Great class. This is the first time I've seen it.
Oh, you're so nice.
So appreciate it.
Patrick, you got anything else you can think of that you want to?
Only other thing I'd add is in your guys' flyers, like we mentioned, you guys have the roster and we also have our full list of tools and services. So obviously Roberta does escrow. And then there's some additional things that we are able to help with as well.
Was Stewart success in there?
It's on that tools and services list.
Service. Look that over, because there's certain stuff in there that we can definitely help you guys out with, whether it's farming, CRM, social media, anything above those lines. We can definitely get you guys to step up for sure.
Yeah,
These
if
guys are
there's,
amazing. They can sit down with you and go over a lot of the tools we have and kind of walk through some of the things like just talking about the property profiles and they're a nice handy little tool. And so I look forward to you all getting together. And we have whatever the fourth largest title insurer in the country. Stewart. And that there's some that packs a punch, and we have some great local underwriting, flexible. And I'm not trying to say, we're not just gonna insure any old thing, right? But we are willing to look at things that really, that customer service aspect is important to us as a company. And these guys are start here, and we have some other salespeople that, and like I said, lots of offices and lots of great escrow talent, years and years of experience.
And that's what sets us apart and different from other companies as well, as our knowledge, our communication, our relationships, especially our title department is top notch. They think outside the box. If they can't get it done this way, okay, then let's find a different way. The answer is never no. It's like, okay, how do we do it? And that sets us apart from the other companies.
oh, well, thanks. I mean, that's kind of title, right?
Right. Hey, it's all the creative side of the brain too. Well, thank you guys so
Thank you
much.
guys.
Don't hesitate to reach out. If you have any questions or anything,